At the time of recording this audio, I had scheduled for oral sessions to be a breakout sessions when after we have done something substantive, like we have just concluded the criminal litigation course outline session 1, we jump to orals, quick fire questions and answers. Then after orals, quick fire question and answers, we resume back to analysis of I had planned to jump into civil litigation, commercial transaction. Yeah, so basically we will jump into the next in line. I'll confirm from my records what is the next in line cause outline to review. So briefly, question and answer, oral questions. If the family, question 441. Question 441. If the family of a Kenyan who has been unlawfully killed by police sues for constitutional violations, and at the same time the DPP has instituted investigations, is it possible for the High Court to assume jurisdiction? And the simple answer is yes. The High Court can assume and exercise jurisdiction over a constitutional petition for an unlawful police killing, even while DPP investigations are ongoing. Parallel criminal processes are not by themselves a bar. The court will typically avoid micromanaging investigations and prosecution unless clear illegality, bad faith, or abuse of process is shown. Okay. Remember, if you read Article 165(3)(b) of the Constitution of Kenya, it provides that the High Court has jurisdiction to determine questions on enforcement of the Bill of Rights and constitutional interpretation. Okay. Then there is DPP independence, because the DPP will exercise prosecutorial power independently. This person under Article 157(10) of the Constitution of Kenya, but must have regard to public interest, administration of justice, and avoid abuse of legal processes. So the existence of a pending civil process is not a ground to stay or prohibit or delay criminal proceedings. This is direct interpretation of Section 193A of the Criminal Procedure Code. Okay, so the same can run in parallel. Then the next question, 438. What is the responsibility of a judge in respect to social media activities? A judge must use social media in a way that protects and is seen to protect judicial independence, impartiality, integrity, confidentiality, and public confidence, meaning that no commentary on pending or impending cases, no private interactions with litigants or counsel about cases, and no posts that create bias or the appearance of bias. Okay, this is pursuant to the Judicial Code of Conduct, pursuant to Section 30 of the High Court Organization and Administration Act, Section 29E of the Supreme Court Act, and then Section 47 of the Judicial Service Act, where we have power to make regulations, including the Code of Conduct and Ethics. If we read the Chitembe versus Tribunal appointed to investigate his conduct, we say that private communications and case-related engagements, including via electronic means, can ground removal for breach of the code and gross misconduct. Then 439. What is your understanding of sexual harassment in the workplace? Sexual harassment in Kenya workplace is any unwelcome sexual conduct, quid pro quo, or hostile environment conduct by an employer, representative, co-worker that is offensive and has or threatens a detrimental effect on the employee's employment, performance, or job satisfaction. Okay, and to be precise, because this information can also be used in LPM, statutory definition of sexual harassment includes where a person in authority, directly or indirectly, 1, makes a promise of preferential treatment or a threat of detrimental treatment or employment status consequences linked to sexual conduct, or uses sexual language, can either be spoken or written, where he uses sexual visual material or sexual physical behavior that is unwelcome or offensive and by its nature has a detrimental effect on employment, job performance, or job satisfaction. Then if you read Section 6 of the Employment Act, it says that employers with 20 and above employees must issue a sexual harassment policy statement after consultation covering definition, entitlement to harassment-free workplace, reporting mechanism, confidentiality, and disciplinary measures. So whenever you have been told to give the key components of a sexual harassment policy, is that this policy should have a definition of what amounts to harassment, sexual harassment in the workplace. This sexual policy must have a reporting mechanism, a confidentiality mechanism, and disciplinary measures against a person who is to be caught up in this situation. Okay. Question 429. Could you be aware of any appeal which can come directly from a tribunal to the Court of Appeal without passing through the High Court? And the answer is yes, but only where the tribunal's constitutive statute expressly provides a direct right of appeal to the Court of Appeal. Otherwise, you must go through the High Court or the Specialist Superior Court or use judicial review or supervisory jurisdiction as applicable. Remember, the Court of Appeal jurisdiction includes appeal from the High Court and any other court or tribunal as prescribed by an Act of Parliament pursuant to Article 164(3) of the Constitution of Kenya. Okay, a right of appeal is statutory. If the enabling act is silent or makes a decision final, you cannot invent a direct appeal rule. You may only pursue whatever review or supervisory mechanisms the law will allow. Okay, that was the adequate answer that the panel is expecting to hear from you. Question 422. When the government acquires land compulsorily and then uses a portion of the land and does not use the remainder, what is supposed to happen in a situation like that? Remember that the portion that has not been utilized, it does not automatically revert to the former owner just because the state hasn't used it. Instead, the law gives the former owner a preemptive right to reacquire if the public purpose fails or ceases, and courts will police any diversion to non-public or private use. After compulsory acquisition and payment, the land vests in the state absolutely. This is pursuant to Section 124 of the Land Act. If after compulsory acquisition, the public purpose or interest justifying the acquisition fails or ceases, the National Land Commission may offer the original owners or successors a preemptive right. This is where the examiner will be keen at. This is where the panel will be expecting to hear from you. The National Land Commission may offer the original owner or successors a preemptive right to reacquire the land upon refund of the compensation paid. This is pursuant to Section 110(2) of the Land Act. So you have to take note that no automatic reversionary interest after compulsory acquisition. Okay? And mere non-use or delay is not by itself enough to trigger reversion. If the acquiring entity still intends to use it for the project, courts have rejected give it back claims. This was seen in the case of Erastus Njonjo Mote versus the Attorney General, a 2017 decision. So that is what the panel was expecting to hear from you. If the state has abandoned the purpose, okay, you write to the NLC demanding invocation of Section 110(2) of the Land Act. And you are writing for them to offer you a preemptive reacquisition terms and be ready to refund the compensation received for that portion. It is a give and take situation. 423. Is there a policy or guideline as regards what happens when a land lease comes to an end? And the answer is yes. The policy guideline is mainly statutory. On expiry, the leasehold ends, and for government or public land, the land reverts to the lessor. But the lessee must have a statutory preemptive right to be allocated or renewed subject to conditions. If the tenant holds over and rent is accepted, the law can imply a periodic tenancy. Remember that Section 13 of the Land Act gives a preemptive right plus notice before expiry. This is where the commission or lessor must, within 5 years to expiry, notify the lessee of the expiry date and the lessee's preemptive right to allocation upon application. If the lessee is a Kenyan citizen and the land is not required for public purposes, okay, then you must read Section 60 of the Land Act. This is where we have holding over after expiry. If the lessee remains in possession after expiry or termination without consent, lease obligations continue until they leave. If the lessor accepts rent for 2 months, a month-to-month periodic lease is deemed. Okay. (423) Is there a policy or guidelines? I believe I've answered that question. That was a repetition of the same. 453. What is their view on the argument that a statute remains valid until and unless it is formally repealed, even if it might conflict with the Constitution? In Kenya, a statute does not remain valid in the sense of being enforceable despite a constitutional conflict. It is void to the extent of the inconsistency even before formal repeal, though courts generally presume constitutionality until the inconsistency is demonstrated. Okay? If you read Section 7(1) of the 6th Schedule of the Constitution of Kenya 2010, it tells you that existing law continues in force but must be construed with alteration, adaptation, qualifications necessary to bring it into conformity with the Constitution. Okay? Read the case of Joho versus Shabal 2014. A statutory provision was found inconsistent with the Constitution, is a nullity to the extent of inconsistency, and proceedings founded on it are treated as void. Okay. 458. Regarding deepfakes and the law of evidence, what can the judiciary do when documents or videos appear original but are AI generated? This is a very potential question. The judiciary should treat AI content as a foundational authenticity problem. Insist on strict electronic evidence foundations. Do you know the source? Do you know the provenance? Do you know the integrity? Require proper Section 106B of the Evidence Act certification or maker testimony. Admit only what is proved and then discount or exclude what cannot be authenticated, often with forensic assistance and chain of custody directions. Remember Section 78A of the Evidence Act that says admissibility and weight of digital evidence. Electronic or digital evidence is admissible, but the court must assess reliability of generation, storage, communication, integrity, and identification of the originator. Okay, so we must check reliability, integrity, and identification of the originator. Then you have the mandatory foundation for computer outputs, because admissibility turns on compliance with conditions in Section 106B of the Evidence Act. This is where we require certificate of electronic production. Okay. 460. If an application is made to amend a previous affidavit because the party changed their mind about what they said, what would your ruling be? If I'm a judge, I would refuse leave to amend the affidavit to reverse substantive sworn facts merely because the deponent has changed their mind. The proper course is to file a further or supplementary affidavit explaining the change and leave both versions on record for it, if necessary, cross-examinations. If you read Order 19, Rule 7 of the Civil Procedure Rule, affidavits are evidence on oath. The court's tolerance is for formal or technical irregularities, not just rewriting sworn testimony. This is where the court will give a tolerance on misdescription or title and even jurat errors. Then if you read Order 19 or Rule 6 of the Civil Procedure Rules, it says that the court may strike out scandalous, irrelevant, oppressive matter from an affidavit, but it is different from permitting a deponent to reswear new facts as if the earlier oath never existed. So the court may strike out in itself scandalous, irrelevant, or oppressive matter from an affidavit. Then if you read Order 19, Rule 2 of the Civil Procedure Rules, where evidence is by affidavit, the court may order the deponent to attend for cross-examination to test the contradictions. Okay. Then there are some decisions that have categorically said that substantive amendment to an affidavit is generally impermissible, and affidavits cannot be edited to alter the substance of sworn evidence. That was the case of Omar versus National Land Commission 2024. Okay, that we have answered to the best of our abilities. Then 449. If the court refuses to enter a nolle prosequi and the DPP refuses to tender evidence to frustrate the court, what happens then? If the court declines to permit discontinuance, or what we call nolle prosequi or withdrawal, and the DPP then refuses to call evidence, the court should not be held hostage. It will either, 1, treat the prosecution as having no evidence and acquit at the no case stage where the law allows, or B, in the alternative, discharge or terminate for want of prosecution or abuse of process and make consequential orders, including bail, cancellation, and release. Remember that Section 82 of the Criminal Procedure Code says that the DPP cannot discontinue without a court permission. The CPC nolle prosequi mechanism discharges the accused once entered and does not bar a fresh case. Okay. Withdrawal in subordinate courts. Before the defense is called, withdrawal leads to a discharge and not a bar. Okay. No case to answer acquittal in subordinate courts. If for the close of the evidence supporting the charge no case is made out, the court must acquit. In the High Court, after the prosecution closes, the High Court must decide whether there is evidence. If none, it records a finding of not guilty, pursuant to Section 306 of the Criminal Procedure Code. To avoid a confusion, we can read Section 82 of the Criminal Procedure Code to understand the basis. Okay. The title is The Power of the DPP to Enter Nolle Prosequi. In any criminal case, and at any stage thereof, before verdict or judgment, as the case may be, the DPP may enter a nolle prosequi, either by stating in court or by informing the court in writing that the Republic intends that the proceedings shall not continue, and thereupon the accused shall be at once discharged in respect of the charge for which the nolle prosequi is entered, and if he has been committed to prison, shall be released, or if on bail, his recognizance shall be discharged. But discharge of an accused person shall not operate as a bar to subsequent proceedings against him on account of the same facts. 2. If the accused is not before the court when a nolle prosequi is entered, the registrar or clerk of the court shall forthwith cause notice in writing of the entry of the nolle prosequi to give to be given to the keeper of the prison in which the accused may be detained. That is the direct interpretation of Section 82 of the CPC. Then let us read Section 210 of the CPC. Acquittal of accused person when no case to answer. If at the close of the evidence in support of the charge, and after hearing such summing up, submission or arguments that the prosecutor and the accused person or his advocate may wish to put forward, it appears to the court that a case is not made out against the accused person sufficiently to require him to make a defense, the court shall dismiss the case and shall forthwith acquit him. That is what we reduce to, that if at the close of the evidence supporting the charge no case is made out, the court must acquit. Okay. If the court refuses permission to discontinue, then the case remains pending for hearing. If the DPP then refuses to call evidence, the court gives a final opportunity or elections. If the prosecution persists in calling no witnesses, the court will treat the prosecution case as effectively closed with no evidence. And the outcome depends on the stage. We have seen that if the prosecution offers no evidence at the close, the court should proceed to Section 210 and acquit on a no case to answer if it is in a subordinate court. If it is in the High Court trial, the court proceeds under the clause of prosecution case pursuant to the procedure in Section 3 or 6 of the CPC and records a not guilty finding if there is no evidence. If we read Section 3 or 6 of the penal of this section CPC, let me read Section 3 or 6 in verbatim. Clause of case for prosecution. When the evidence of the witnesses for the prosecution has been concluded, the court, if it considers that there is no evidence that the accused or any of the several accused committed the offense, shall, after hearing, if necessary, any arguments which the advocate for the prosecution or the defense may desire to submit, record a finding of not guilty. Okay. So that was the breaking point of our quick fire oral questions. We will revert back to our analysis of the various acts of parliament that I have fully analyzed. So allow me to end the recording for these quick fire questions.